Good morning, everyone. Welcome to today's hearing. As always, I'm joined today by my fellow panel members, Ms. Thuria Istefan and Mr. Ali Akbar.
Good morning.
Good morning.
Today, we're going to continue hearing evidence from Mr. John Albon of BBA. So my next task is to check that Mr. Albon is not only there, but that he can hear me and see me clearly. Good morning, Mr. Albon. Can you?
Good morning. Yes, I can.
Good. Thank you very much indeed. I think we ought just to run through the usual housekeeping questions before we get back to your evidence. So I'm going to ask you, please, to confirm that you're alone in the room from which you're giving evidence.
Yes, I am.
Thank you. Can you confirm that you have no documents or other materials with you?
No, I don't.
And can you confirm that your mobile phone is in another room and that you don't have any other electronic device in the room with you which is capable of receiving messages?
No, I don't.
Good, thank you very much. Well, you're an old hand at this. The procedure will be as it was on the previous occasions you've given evidence. If you're still giving evidence during the middle of the morning, we'll probably have a break at that point, depending on exactly what point we've reached. Is there anything you'd like to raise with me or ask me before we start?
No, thank you.
Good, thank you very much. Well, in that case, I'll invite Ms. Grange to continue putting questions to you. Yes, Ms. Grange, when you're ready.
Yes, good morning, Mr. Albon. If we can start, I want to go back to the email exchanges you were having with Mr. Brian Martin about amended issue 1 of the BBA certificate for the K15 Kingspan product. And if we can go back to BBA 50178. And if we look at page 2 of that email chain, so looking at your email at the bottom of that page, 16th of July, 2014, 12:14, I'd asked you about the first 2 main paragraphs. And I now want to look at what you say in the second half of that email. So you say, picking it up with the BBA operates, you say the BBA operates a system of leader certificates in which we invite comments from a range of industry experts on the initial draft of each certificate type. And for example, where changes are made to building regulations. For many years, we received such comments from DCLG's predecessors, but unfortunately, we were advised some time ago that you were no longer able to offer this service. I believe that it would benefit to both our organizations as well as the industry as a whole if you were able to reconsider this decision. And you go on and you say in the next paragraph, I've spoken to the BBA's chief executive, Ms. Claire Curtis-Thomas, concerning your inquiry, and we would be very willing to meet with you at your offices to discuss the relationship between DCLG and BBA and how we can work more closely together. Would you please let me know whether you'd be interested in such a conversation? Now, can you just tell me a little bit more about what you had discussed with the BBA's chief executive, Ms. Claire Curtis-Thomas, about Mr. Martin's inquiry? You refer to that at the bottom of this email.
I think I had made Mrs. Curtis-Thomas aware of this approach from DCLG and discussed with her the basis of the BBA's response, in particular whether we could recreate this relationship whereby they were to comment on our certificates.
I see. Did you consider at this time that the BBA was in need of guidance from the DCLG on aspects of the building regulations or the BBA's certification process?
Well, we are able to seek guidance on individual circumstances where, in our view, the situation is unclear, and we continue to do so. This was more a procedural situation whereby if we could gain comment on the content of certificates from those responsible for the approved documents, clearly that would be an improvement to the process.
Yes, and you were specifically wanting comment on each leader certificate from DCLG, is that correct?
Yes.
And you're saying that for many years you received such comments, but unfortunately you were advised some time ago that DCLG was no longer able to offer this service. In your view, had the accuracy of BBA certificates worsened with regard to the building regulations after the loss of that DCLG commenting process?
I don't believe the accuracy had worsened, but we would have a greater confidence in the content of certificates if those responsible for the building regulations had reviewed them.
Yes, I see. Now, if we go up to the next email at the top of page 2, we can see that this request that you made from DCLG was declined. Mr. Brian Martin responds to you the next day, 17th of July. And we can see, just focusing for a moment on the final paragraph of his email, he says, I note your comment about the relationship with DCLG and BBA. I think things have significantly changed over the years, and my understanding is that your status is similar to any other certification scheme. I very much doubt we could support all the various schemes in the way you suggest. Now, what was your reaction to that response?
It was consistent, I think, with the conversations we would have had previously. The BBA at one time had a closer relationship with government than its current organisational status allows. And DCLG felt, I believe, that they had to treat the BBA impartially with other certification schemes that exist.
Yes, I understand that, but what was your reaction? Was BBA disappointed at this point that the DCLG felt unable to discuss this with them?
Disappointed, perhaps not surprised. I think we did make a subsequent second offer that again was declined by DCLG.
Right. Can you help us? When did you make that second offer? And was that also to Mr. Martin?
I think it was part of this correspondence. So it would have been within a few days.
I see. And also, that was also to Mr. Martin, was it? Mr. Brian Martin?
Yes, it was, I think.
Yeah. Did you have any further discussions with Ms. Curtis Thomas about this refusal?
I'm sure I would have made her aware, yes.
Right. And we can see, looking at the first part of Mr. Martin's email, that he asked the following. He says, for completeness, I wonder if you could confirm a couple of things for me. And then in the first bullet, what has BBA put in place since the original certificate was issued to make you so confident this won't happen again? A summary would be fine. And then the second bullet, will you be notifying the manufacturer certificate holder of the issue? And then if we go up to page 1, we can see your response sent a few days later on the 23rd of July. And we can see you say in that first paragraph, the mistake was basically caused by human error. The project manager involved and their line manager no longer work in the BBA's operations department. Now, just pausing there, and just to be clear, what had led you to give this further explanation that the mistake was caused by human error?
I think I made that statement as an introduction to subsequent paragraphs which explained the steps that we had taken. Unless Mr. Martin understood the reason for the error, there would be no context as to whether or not these corrective actions were appropriate. Yes,
I understand you might have put that in as part of the context for the ways in which you've addressed the issue in the following part of the email. But I want to understand, why were you stating at this point that it was caused by human error? What had led you to that conclusion?
Well, as we discussed, the statement was open to misinterpretation. and that was as a result of it being poorly phrased. That I would describe as a human error.
I see. So you had concluded, had you, that the person drafting a certificate had made an error when they were drafting it, yes?
Yes.
And we know at this stage, and I don't think at all, you'd never mention the diagram 34 exception point that you mention in several places in your inquiry statement. That's correct, isn't it?
Yes.
And why not?
Well, the diagram 34 is the only scenario in which that statement could have been accurate, but it does not change the fact that, the statement itself is capable of misinterpretation. So in this context, I felt it was irrelevant.
Right. Yes, thank you. Now, just focusing on that second sentence, you say the project manager involved and their line manager no longer work in the BBA's operations department. And you've told us in your witness statement, this is third statement, page 50, paragraph 198, that the two individuals were George Lee and Chris Hunt. Now, were you meaning to suggest in this email that those two individuals had been moved to other parts of the business or had left, as in Mr. Lee's case, as a direct result of this issue?
No, not at all.
No.
Lee left for his own reasons, and Mr. Hunt had made a career move to a different part of the organisation. It was entirely unconnected with this issue.
Yes, quite. So that would not have been correct, would it?
In what way would it not have been correct?
Well, it wouldn't have been correct to suggest that they had left as a direct result of this mistake in this issue, yes?
No, it wouldn't, but I don't believe I'm saying that.
I see. I'm just seeking clarification of what you are saying. Now, you continue on in your email. In the second paragraph, you say we are addressing the overall issue in 3 ways. We have introduced a new training program for all staff, focusing on both technical and procedural matters. An additional level of checking has been introduced by a new management structure. We have placed more emphasis on certificate templates, which are commented on by internal and external experts prior to finalising, as referenced in my earlier email. And then you carry on in the next paragraph. There would have been a dialogue with the certificate holder as part of the reissue process. And I would expect that this would have been pointed out. The certificate holder would not claim that the material is of limited combustibility. And this has never been stated in the certificate, which did correctly give only a class 0 rating. I think that the chances of anyone inferring limited combustibility to be extremely unlikely from the certificate wording. And while the error is, of course, of concern, I am pleased that we recognised and corrected it. So just looking first at that very last sentence where you say, I am pleased that we recognised and corrected it. Why do you say that in this email? I am pleased that we recognised and corrected it.
It's simply the fact that the certificate in question was no longer current and had been replaced by the 2015 version. Sorry, yes. The second issue.
Yes, but you told us in your statement, and you confirmed yesterday, that the changes to that certificate were entirely unconnected with this issue and were to do with more substantive structural changes to the information contained in BBA certificates.
Perhaps that is slightly over-analysing what I'm attempting to say here. The point I was trying to make is that we had replaced that wording with the then current certificate.
Now, just to be clear, you're representing to Mr. Martin by these words, are you not? That you had already recognised this matter as an error prior to receipt of this email, and that the certificate had been revised in December 2013 in order to correct that error. That's what you're saying here in this email, isn't it?
That's not the intention. The intention is that the wording has been removed from the then current certificate.
I see. Well, that's the point I'm putting to you, that representing that the error had already been corrected prior to receipt of Mr. Martin's email, and that the certificate had been revised in order to correct it, was not true, was it?
I can see how you would form that impression from the words that I chose, but that was not the intention at the time. I was purely trying to say that, yes, this certificate was capable of misinterpretation, but the current version does not include that wording, and therefore that possibility no longer exists.
Yes, but you don't say to him, you should be aware that due to reasons unconnected with this error, the certificate has already been changed. You don't say that, do you?
No.
No. And you had only been alerted to this problem because of Mr. Martin's email in July 2014. That's right, isn't it?
Yes.
And you appear to be suggesting in this email, is this right, that the new training programme, the additional level of checking and the emphasis on certificate templates had all been introduced at some earlier stage in response to or as a result of this error? Do you agree? That's how it reads.
No, I don't. I read it that these measures were put in place to minimise the possibilities of human errors occurring, rather than in response to this specific issue.
Well, the question you were answering was Mr. Martin's question. What has the BBA put in place since the original certificate was issued to make you so confident this won't happen again? So I'd suggest to you that it does read in that way, that you're suggesting that these measures have been put in place in response to the error that you're saying or representing in this email you had already recognised.
No, I don't agree. I say we are addressing the overall issue, not this specific issue. And I think by the overall issue, I meant the possibility of human errors occurring in the wording in a general sense.
Now, in terms of Mr. Martin's question about whether or not the manufacturer had been alerted to the error, isn't this right that you could not in truth answer that part of his question because you hadn't known until you heard from the DCLG a few days before this that there was anything to alert the manufacturer to?
Yes.
Was Kingspan ever told about the problem with that certificate, that reissue of the first certificate? Was Kingspan ever told that at any stage?
No, we did not feel that was necessary.
Why not?
Because we did not feel it was technically significant. We felt the possibility of someone inferring a limited combustibility classification was very low, given that nowhere in the certificate did it state that it was of limited combustibility.
So Mr. Martin has drawn to your attention what he considers to be a serious error in a BBA certificate. And he's asking the question, has the manufacturer been contacted about this? And you're saying they were never told about this. Is that right?
We made 2 offers to discuss this with Mr. Martin, partly because we did not understand the basis for his concern.
Wasn't it important for Kingspan to be told that a human error had occurred with this certificate, that you had recognised it was an error, that it had subsequently already been corrected? But what, in any event, was it important that Kingspan were aware of that and knew that you considered that to be an error at this time?
It was one clause that had the potential to be misinterpreted. We did not feel, and I still do not feel, it was significant technically.
Did you speak to Mr. Hunt, who was still employed by the BBA at this time, about any aspect of this matter?
I don't recall if I discussed it with him at the time. There is nothing on file I can see to suggest that I did, but I may have done.
His evidence was that you mentioned this matter to him, but he thought that that was after you had replied to Mr. Martin. Is that right?
I don't know. It's possible.
Let's just look at Mr. Hunt's evidence. If we can go to the transcript, day 109, page 63, starting at line 4. So Mr. Hunt is being asked about this email chain, and he's asked, have you seen that email previously? And he says, yes, I think I've seen the chain of emails. When? And then he says I think it was shown to me at the time when John Albon was, when he replied to it. And then he's asked, so do you mean in person? You and he had a discussion, or are you talking about emails? Oh, I think in person. I think he told me that he'd had it and that he'd replied to it. And I think he showed me the reply. I don't think he emailed it to me. I think it was just a hard copy. And then the question is, I see, just to be clear, the first that you became aware of this intervention from DCLG was through a face-to-face discussion with John Albon, by which time he'd already replied to Mr. Brian Martin. Is that correct? I think so, yes. I can't be absolutely sure of the precise sequence, but it was at this time of the reply. Whether he showed it to me before he sent it or after, I can't remember. So his evidence was not entirely clear, but does that help you? He thinks that you had a discussion with him, but it was likely to be after you had already sent your responses to Mr. Martin.
I still don't know, I'm afraid. John Denyer carried out the investigation. It may be that he spoke to John Denyer. It may well be that he and I did speak about it afterwards, but I really don't remember.
So just to be clear, you didn't speak to Mr. Hunt, who was the head of approvals at the time that this certificate was issued. His name was on the certificate. You didn't think to discuss the issue with him before you went back to Mr. Martin?
As I said, I may have done, but I don't remember. Equally, John Denyer may have spoken to him as part of his investigation. I don't know.
I see. On what basis, going back to your email to Mr. Martin, if we could bring that back up. So BBA 50178, page 1. You say in that penultimate paragraph that you think it's the second line from the bottom. You think it would be extremely unlikely that anyone would have inferred limited combustibility from the reference to 12.7. How did you reach that conclusion?
From the fact that nowhere in the certificate is there any reference to that material achieving a limited combustibility classification.
So was that just your own thoughts on the matter, or did you speak to any of your BBA colleagues about this before reaching that conclusion?
I would have spoken to John Denyer about it.
I see. Did being contacted by the DCLG in this way make you question the BBA's practices and procedures around fire performance certification and whether improvements needed to be made?
Yes, of course. There had been a significant number of changes made to our processes and procedures since that error was made, as I've described in this email to Mr. Martin. It was an ongoing process of continual improvement, and we're always looking for ways to improve the way that we work.
I see. So did you think there were further changes that ought to be made after you'd received Mr. Martin's email in order to improve the way the BBA was certifying fire performance on its certificates?
It's not specific to fire performance, it's all aspects of our certification process. And yes, since this time we have made further improvements to the way that we work, and we will seek to continue to do so moving forwards.
Was this recognised within the BBA as an important moment when you came to be aware of a serious safety issue arising from the fire performance wording in one of the BBA certificates?
Again, I don't agree this was a serious safety issue. I think we had addressed the issue that was raised. We had explained to DCLG the measures that we had taken. We had made 2 offers of a meeting to further discuss the issue and perhaps understand the context of his initial inquiry. The fact that we received no further correspondence from Mr. Martin and the fact that he declined to have these meetings suggested to me that he was satisfied with our response.
You said there, I don't agree this was a serious safety issue. Do you genuinely not consider that there was any risk in stating that K15 could be used in accordance with 12.7 of ADB? Is that genuinely your view, that there was no risk in the BBA having stated that in terms of safety?
I think there is no risk of a suitably qualified and experienced building professional inferring from one number inserted in the certificate, one clause number, that product was of limited combustibility. I think the certificate would have been read in its entirety, and a suitably competent individual would understand that unless the BBA certificate states that a material is of limited combustibility, they should not infer that from a single sentence.
I see. Can I just look finally on this subject at something you say in your third witness statement? If we can go to that, top of page 49, paragraph 191. I want to pick this up about 7 lines down. There is a sentence right in the middle of the page beginning, if the BBA considered. So you say, if the BBA considered that a product was a material of limited combustibility, the certificate would clearly state this. That's what you've just said. The BBA certificate did not state that the product was of limited combustibility. Therefore, a reader with the necessary level of knowledge and experience would know that it could not satisfy clause 12.7 for a rain screen construction above 18 metres unless the specific construction met the requirements of BR 135. The error lay in not making this point specifically within the certificate, leaving it open to some interpretation. And then you say this, to be clear, I believe that the certificate wording was technically correct and that a suitably competent reader would have no difficulty in understanding the meaning. This might not, however, be the case for a casual examination, which is not the intended readership. Now, I just want to ask you about whether that remains your evidence. Do you still believe that the certificate wording was technically correct, as you have said there in your witness statement? Or are you now accepting that, in fact, that was an error that was misleading?
I think it was an error. I think it was capable of misinterpretation. But in one specific scenario, the statement made was true. So I want to know, are you maintaining that part of your witness statement where you say, I believe that the certificate was technically correct and that a suitably competent reader would have no difficulty in understanding the meaning? Does that remain your evidence? Yes. I want to move on now briefly to look at issue 2 of the BBA certificate, which was published on the 17th of December 2013, just 5 months after amended issue 1 had been published in July 2013. Now, going back to your third witness statement, actually, we don't need to go to it. I think I can summarise what you tell us on page 33 and paragraph 124 is you're asked who was responsible for checking the wording of section 8, that's the fire section of that second issue of the certificate. And you tell us that it was initially checked by the team manager, Ms. Ramkaran. Work was first supervised by the then head of approvals, Sean Moriarty, but you tell us Mr. Moriarty left the BBA prior to the issue of the certificate and that you replaced him in that role. So the final wording was approved by you, is that correct? Yes. And we can see that from page 1 of the certificate. If we can bring this one up, it's at BBA 6036. We can see there that your name appears in the pale blue box at the beginning of this page as head of approvals, and that's your signature, yes? Yes. And do you accept that in approving the final wording, you were ultimately responsible for the checks on and the sign-off of all technical assertions made within this certificate? Yes.
And we'll come back to it in a moment, but if we just note that under behaviour in relation to fire, all it says there is the product will not contribute to the development stages of a fire or present a smoke or toxic hazard. Yes?
Yes.
So that sentence, which both you and Mr. Hunt couldn't explain to us, that stayed in this second issue of the certificate, yes?
Yes.
And if we go now to the bottom of page 5, the fire section is now section 8. We can see it starts right at the bottom of that page. And we can see that this says at 8.1, the product is classified as class 0 or low risk, as defined in the documents supporting the national building regulations. Now, can you help us? Since the first version of this certificate was published in 2008, had the BBA ever actually sought test data from tests to BS 476 Part 6 and Part 7 from Kingspan supporting that statement?
This was a reissue for specific additions to the certificate. It was not a repeat of the original technical assessment. So no, we would not seek information that should already have been on the technical file.
But just to be clear, that information was not on the technical file, was it? There was no 476 Part 6 or Part 7 data?
No, it wasn't.
Now, we're 9 years on from the request to Kingspan that we saw in 2004 for reaction to fire and surface spread of flame data. We looked at that letter from the 2nd of December 2004 from Mr. Simon Lloyd. Didn't it occur to you at this later stage to request some up-to-date data from Kingspan supporting that statement?
No. As I said, the reissue was to add specific sections to the certificate or specific changes to the certificate. It would not involve a reassessment of the data on which the original certificate was issued.
Can you help us then, when in December 2013, when you came to approve the content of this certificate, what did you think the basis was for that classification as class 0?
The normal situation would have been for the BS 476 parts 6 and 7 reports to be on file.
Yes, I understand that's the normal situation, but that's not an answer to my question. Can you help us? When you came to approve the content of this certificate, what did you think the basis was for that classification of class 0?
I would have had no reason to consider that as part of the reissue of this certificate, which, as I say, were for specific amendments as defined in the contract documents. It is not a reassessment or a re-evaluation of the original certification.
I see. Can you help us then? What was the exercise that you carried out? Your name appears on the certificate, you've signed it off, you're responsible for the technical content of it. So can you talk us through what exercise you actually did when you reviewed this certificate?
I would check that all of the contractual requirements had been met for this specific reissue and check that wording. I would, of course, reread the whole certificate before signing it, and I made an error in not recognising an inappropriate clause on the front page, which I regret. I would not go back and check that the statements made relating to the original assessments were justified.
I see. So when you say I checked that all of the contractual requirements had been met for this specific reissue, what does that mean? Was it a contractual requirement for Kingspan to provide test data supporting each of its claims in the certificate?
No, we would need to examine the contract documents. They would be for specific amendments to be made to the existing certificate. I don't remember, I'm afraid, what those specific requirements were. It was not a re-evaluation of the whole certificate.
I see. So you check some contract documents to ascertain whether the amendments are covered by those contract documents?
I would check that the contractual requirements have been met, that the changes we made in the contract had been made, the wording was correct, and that the statements we made, the new statements we made, were justified.
And how would you check that the wording was correct and that the statements you'd made had been justified if all you're doing is reading the certificate itself without checking any of the underlying test data or any of the underlying information on the file?
I'm sorry, that's not what I said. I would check the underlying information on the file for the new parts of the certificate. I would not go back and redo the original assessment.
I see. So you confine your review to only checking those bits that have changed, and anything that was in there originally, you don't, for yourself, ascertain that there is in fact evidence supporting those statements.
I would reread the whole certificate and make changes as appropriate given the current BBA wording for a given product type. Clearly, I would read the whole certificate. I'm taking responsibility for it. I would not go back, for example, and check that we had BS 476 reports on the file from 2008.
I see. So does it follow that when you read that class note statement, you would have just read it, noted it, moved on, but not carried out any form of checking?
Out by others as part of the original assessment of the product. So I had no reason to suppose that would not have been carried out.
I see. If we go further down the certificate, we can see, if we go to page 6, section 8.2, the certificate states, it says when tested to BS 8414 Part 1, 2002, the following specific cladding construction met the criteria as stated in BRE report BR 135 2013, and then the construction is set out below that. Now, just pausing there, were you aware at the time you approved this certificate that this BS 8414 test was undertaken in 2005 and was therefore now 8 years old?
I don't recall, but probably.
If we could just look briefly at something you say in your third witness statement about this, if we go to page 42, paragraph 164, that's BBA 30100751. You say this, you say the BBA does have a policy of not normally accepting test reports for new assessments that are more than 5 years old, which is consistent with the above. However, in this case, the BBA has had the production under surveillance and can be assured that there have been no changes to the formulation or specification of the product. In these circumstances, as the product is unchanged, it is reasonable to assume that the performance in respect to fire testing will also be unaltered. Now, can we take it from that, therefore, that in fact the BBA's policy is to accept test reports which are more than 5 years old, unless the manufacturer has alerted the BBA to changes to the formulation or specification of the product?
No, I don't think so. If it is a new assessment for a product, we are not operating a process of surveillance. We will not accept a report that is more than 5 years old. Once we have accepted a report, certified the product, and then have the production under surveillance, we continue to accept that data as being representative of the performance of the product, on the understanding that the formulation and specifications are from that point onwards unchanged.
Yes, I follow. I think that is a longer version of what I put to you. Is it your understanding that Kingspan at no stage alerted the BBA to any such changes in relation to the formulation of the product?
There may well have been changes during the surveillance of the product. I'd have to look at the data on the file, but that's all I can say, I'm afraid, that there are always minor changes made during the course of production.
Yes. Would it be normal in your experience for no changes at all to the formulation or specification of an insulation product to take place over the course of a decade?
No, that would not be normal.
And did you actually check at the time whether there had been any changes to the formulation or specification of this particular product?
No, if any changes are made, They are addressed at the 6-monthly surveillance audits that we carry out. A technical assessment is made of any changes that may have been made, and any additional technical work necessary is carried out at that point. If that had not been the case and there had been issues that had not been addressed, then the certificate would be suspended.
I see. Now, in this instance, changes to the formulation are not particularly relevant to whether or not K15 could still achieve class 0, because a classification to class 0 had never actually been established by evidence for K15 in the first place, had it, back in 2008?
But this is in reference to an 8414 report, I think we're talking.
Yes, sorry, I'm now asking you about changes that are relevant to class 0. I'm going back to that. I want to understand how changes in the formulation were relevant, given you'd never got a baseline. You'd never got the evidence in the first place of satisfaction of the class 0 tests.
That's correct, we did not. However, as you know, achievement of class 0 would not in itself be sufficient to allow the use of the product above 18 metres.
No, I do know that. Thank you, Mr. Albon. But I'm still trying to explore how that statement made its way onto this certificate, which you signed off on. Do you accept that it was a basic failure of due diligence on the part of the BBA to allow that class 0 statement to appear on this certificate in circumstances where the BBA had never had proper supporting test data?
Yes, I think I acknowledged that yesterday.
And do you accept that it was a basic failure of due diligence on your part, given that you signed off on that certificate?
I think I followed the BBA's procedures, which are reasonable, and in doing so, I perpetuated the original error. So, possibly.
Oh, I see. If we go back to the certificate at page 6, we can see that there is a little footnote in the section that I just read you about the 8414 test. Can you see it says 8.2 when tested, and then there's a footnote number 1, and we can see that that footnote number 1 refers to a section just underneath that detail about the construction. It says the test result relates only to this specific construction, and a separate test would be required to establish the performance of any other combination of materials. Now, do you remember noticing that? Because that was different, wasn't it, from the previous version of the certificate?
Yes, it is.
Can you help me? Would you have the previous versions of the certificate in front of you when you came to sign off on a later version?
Yes, there would be a track changes Word document, so you could identify the original text and the changes that had been made.
Now, in terms of that footnote there to section 8.2, are you aware that Kingspan saw the placement and the size of that text as something of a victory in terms of the final version of this certificate?
I was not aware of that before it was identified in the inquiry.
Does it surprise you that Kingspan treated it as progress for them, that requirements which limited the scope of the use of K15 were buried deep in the certificate?
It does surprise me, though I would argue that the limitations are placed by the approved documents, not this certificate.
Yes, but just sticking with this certificate, what we can see is, you see, if we go back to page 1, and under key factors assessed, behaviour in relation to fire, as we noted when we first looked at this, there's only one sentence there: the product will not contribute to the development stages of a fire or present a smoke or toxic hazard. And a sentence has been removed from the previous version, which had said in that position on the certificate, the product has been tested to BS 8414 Part 1 for a specific construction on masonry walls, see section 7. Now that sentence has been deleted on the front of this certificate, and that limitation is only expressed in the footnote on page 6 that we just looked at. Now, did you notice that change when you came to review the certificate?
I would have done. I think you should have added, when you read the text under behaviour in relation to fire, see section 8, because this is only intended to provide a brief summary and to direct the reader to the section of the certificate where the full information is given. Similarly, in section 8, in bold text, it does say this specific construction was tested. So it is not only the footnote that makes that point.
Yes, I understand that. But what I'm seeking to get to the bottom of is why remove the sentence, the product has been tested to BS 8414 part 1 for a specific construction on masonry walls. You see, that was a sentence that in late 2008, the BBA had asked to be added into this certificate to make it clearer to the readers what the limitations were of that 8414 test data. So can you explain to us why that sentence comes out of this front page and that sentiment is now only expressed in a very small footnote on page 6?
Because it is not possible to give a full and accurate representation of the detailed fire performance of the product in a one-line summary on the front page. For that reason, we refer the reader to the full text in section 8, which relates not only to BS 8414, but also Class O and the fire resistance of the product. I understand why you're focusing on BS 8414 because it is specific to this particular case, but the BBA certificate covers all aspects of fire, not merely the 8414, and it didn't warrant emphasising on the front page.
Yes, but you see, Kingspan had very little fire test data at this time, which was why the BS 8414 test was so critical. Did you understand that at the time?
I would argue the fire resistance of the product is equally critical. The Class O performance is equally critical, and we cannot put all of that information on the front page.
Yes, and I see you say there the Class 0 performance is equally critical, and we've already been through that. Did you actually notice at the time that that sentence had been taken off the front page and instead a small footnote had been inserted? Do you remember actually noticing that when you reviewed the certificate?
This is one of hundreds, if not thousands, of certificates that I have reviewed over that period. I don't remember looking specifically at that clause now, no, but I would have read it.
Do you believe that you gave the technical content of this certificate the attention it required before you approved it for publication, and that your own work on it in terms of checks was competent and adequate?
I believe I gave it the attention it required. I made a mistake on the front page by retaining a misleading statement.
Mr. Albon, before we leave section 8 of the certificate, can I just ask you this? You'll recall that the footnote is quite an important qualification, isn't it, on the passage that precedes it?
Yes.
The footnote is printed in quite small type, isn't it?
Yes.
Why is that?
It's standard BBA house style for any footnotes we incorporate into certificates. It's not specific to this certificate or this clause.
You don't think it was important for a qualification of that type to be more, to stand out more?
With hindsight, possibly, but I would expect the reader of the certificate to understand the text, to read all of the text. And it does say in the first line, I believe, that it was that specific construction that had been tested.
Yes, all right. Thank you very much. Yes, Ms. Grange.
Yes, thank you. Mr. Albon, I just want to come to some general questions now at the end. It's right, isn't it, that the BBA is held in very high regard in the construction industry? Is that right?
Yes.
Can we just look at something that Paul Hyatt, the inquiry's expert architect, has said in his report? If we can go to PHYR 604 at page 116. And at paragraph 4.4.56, he says this. He says, I believe that architects should be able to place reliance on a BBA certificate. In support of this view, I quote from the BBA's website and add some exhibit slogans as follows. And if we read the quotes he's got there: product approval and certification. BBA certification is recognised throughout the construction industry as a symbol of quality and reassurance. It is the vital ingredients in the provision of assurance, quality and integrity to a plethora of stakeholders in the construction industry. Certification is an achievement that delivers the power of product confidence, industry satisfaction and market leadership. Recognised, respected and sought after by specifiers, architects and contractors, reassures all parties that you are an expert in your speciality who stays on top of the latest advances and best practices so you can deliver the safest, most efficient and highest quality product possible. And then if we go over the page, you can see that he's set out some extracts from the BBA website here. And under About Us, it says, the BBA sets the standard for excellence in construction products and systems. We offer technical expertise, are independent with an unrivaled track record, and offer more than certification through our audit and inspection and test services. And then below that, it says, we are the leading authority on building product certification, a position we've held for more than 50 years. With a technical integrity founded on our independent approach and delivered by the industry's recognised experts, we can also leverage our unrivaled track record to accredit building systems using the same trusted, non-partisan approach. So conveniently, Mr. Hyatt has summarised for us there what we see on the BBA's website. Now, looking back and stepping back at what occurred with the Rayner Bond and the K15 certificates, can we agree that starting with the Rayner Bond certificate, there was a serious failure by the BBA to obtain all relevant fire test data when the certificate was first issued, specifically failure to obtain any fire test data relating to the cassette fix variant of Rayner Bond 55?
I agree we did not have those documents in our possession. I do believe it was the responsibility of the manufacturer to supply them to us and that they deliberately withheld them. Our procedures are not designed to cope with that scenario.
So do I take it from that you don't accept there was a serious failure by the BBA to specifically obtain that fire test data?
We were unable to obtain that fire data, yes.
Yes, but do you accept that was a serious failure by the BBA?
I would argue it was a serious failure by the manufacturer to properly declare the actual performance of their product.
Moving on, do you accept there was a serious failure by the BBA to properly scrutinise such of Arconic's fire test data as Arconic had given you when the certificate was first issued?
Yes, we should have explained that the fire test data was specific to the rivets product.
Yes, and that led to the erroneous and misleading statement within the BBA certificate that the panel was fit for its purpose in fire, both as a rivet fix and as a cassette fix, yes?
It would have been fit for purpose in fire in certain scenarios, but not in all scenarios.
No. And as a result, the certificate was materially misleading about the panel's true performance in fire, yes?
It was certainly capable of being misinterpreted, yes.
And there was also a serious failure in the review of the certificate between 2013 and 2015, which resulted in the review being completed and the certificate remaining in circulation without Arconic confirming that there had been no changes to the product which invalidated the certificate.
A decision was made as the BBA procedures allowed that the information available to the BBA gave sufficient reassurance to conclude that the product continued to represent the actual performance of the system based on the information provided by the certificate holder.
So does it follow from that answer that you don't accept that was a serious failure in that review process?
The review failed to identify that there were additional fire test reports available to the manufacturer that had not been provided to the BBA, yes.
Right. And can we agree that in respect of the K15 certificates now, fire performance statements were made in those certificates which were inaccurate and misleading and which had no proper evidential basis?
In terms of the Class O performance, yes, I would agree.
And in terms of the fire, whether it contributes to the development stages of a fire?
Yes.
A particularly serious error was made when the revised issue 1 stated that K15 could be used in accordance with paragraph 12.7 of ADB, and that error was so serious that the government had to intervene. Do you agree?
No, I don't agree with that statement, as for the reasons I've described.
And the BBA was also extremely slow to implement important changes to the first issue of the certificate, which were necessary to ensure that the fire performance sections of the certificate were accurate, a delay between December 2008 and July 2013. Do you agree with that?
Which specific amendments are you referring to, please?
Yes, so that was the amendment actually that we were just looking at, where you had inserted an additional sentence on the front page saying that it had met 8414 for one specific construction on a masonry wall. That change was suggested by the BBA in 2008, but it was not implemented on the certificate until July 2013.
It was a clarification, but the construction was given, I believe, in the first issue of the certificate, so the reader would have been able to infer that from the information given in the certificate. I do agree that it was improved and clarified in the second issue.
But the point I'm putting to you is that the BBA was extremely slow to implement that important change.
Yes, it took longer than I would have expected, I agree.
In the light of all of that, do you accept that the work of the BBA fell a long way short of the standards of excellence advertised by the BBA on its website?
I agree that mistakes were made and I regret those mistakes, but I still believe that from the information made available to us, a suitably experienced and knowledgeable individual could have drawn conclusions from the contents of the certificates.
Can we agree that by failing to adhere to those standards of excellence, what the BBA did was to give a public stamp of authority and authenticity to false and inaccurate statements by the product manufacturers?
I agree that the BBA certificates were inaccurate as a result of the information not having been declared to us, and so yes, we did support inaccurate claims made by the manufacturer.
Given everything we've gone through, do you also accept that the BBA has been slow to recognise that it was lacking in competence in the area of fire performance assessment?
No, I think I've evidenced that we have put many improvements in place since the original assessment of that certificate, and that our competence is higher now than it was then. We are continuing to do so.
And finally, do you also accept that the BBA has shown itself to be toothless and weak in its dealings with product manufacturers?
No, I don't agree with that.
Why not?
In what way have we shown ourselves to be toothless and weak?
By allowing statements by product manufacturers which are inaccurate to go into BBA certificates and not correcting inaccurate statements in a timely manner.
In terms of being toothless, we took steps to withdraw the Arconic certificates when it became clear to us that these fire test reports had not been revealed to the BBA. That is the ultimate sanction we can take, to withdraw a certificate, and that's what we did.
In 2017?
When it became aware through the inquiry that there were additional fire test reports that had not been revealed to the BBA withdrew that certificate.
Mr. Chairman, thank you. I've come to the end of my prepared questions. If we could have a short break to see if there are any more questions. We haven't had many coming in recently, so I don't think we need to take very long.
Well, it might be sensible to combine this break with the ordinary morning break anyway.
Yes, actually. Yeah.
Mr. Albon, as you heard, Council thinks she's got to the end of her questions, but we always have a bit of a break at this stage, just to ensure that that is the case, and also to give other people who are following the proceedings the chance to suggest additional questions. So we'll take a break at this point. I think we'll treat it as our mid-morning break, and we'll resume at 11:15, please, and then we'll see at that stage whether or not there are any more questions for you. All right?
Okay, thank you.
And as before, please don't talk to anyone about your evidence or anything relating to it during the break. Good, thank you. We'll see you again at 11:15, please.
Okay.
Thank you very much. Welcome back, everyone. We're now going to see whether there are any more questions for Mr. Albon. So I'll just check that Mr. Albon can see me and hear me clearly. Mr. Albon, are you there?
Yes, I can.
Good, thank you very much indeed. So we'll now find out if there are any more questions for you. Yes, Ms. Grange.
Yes, just one more question, Mr. Chairman, please. Mr. Albon, can you help us about this? Why isn't the review process for a BBA certificate a thorough and complete review of all original data, given that the contractual sanction for not doing a review is expiry of the contract and lapse of the certificate? Can you help us with that?
All of our processes have developed and evolved over the years. The current review process is different to those that we have been examining as part of the inquiry. We now do require that we receive a full and written response to every point requested as part of the review process, and the default position, should that not be the case, is that the certificate is suspended until such time as the information is provided.
I see, but can you help us? My question was just slightly different. Why isn't the review process a thorough and complete review of all the original data and all the underlying assumptions that have been made in the certificate, given that the sanction for not doing it is effectively termination and withdrawal of the certificate?
Well, as I said, our processes have developed and evolved, and they are now significantly more robust than they were at that time. And I would expect that all of the necessary information would both be placed on the file, properly reviewed, documented and signed off prior to the issue of that certificate. Given that that is the case, there seems little point in repeating the exercise as part of the review.
I see. Thank you very much. Mr. Chairman, I have no further questions. It's just to thank this witness for coming and assisting our investigations.
Yes, thank you, Ms. Grange. Well, Mr. Albon, as you've heard, those are all the questions we have for you. We're very grateful to you for coming to give your evidence, and I'd like to thank you on behalf of myself and the other members of the panel. It's been very useful to hear what you told us, and that's all we have for you, and you're now free to go on your way. Thank you very much indeed.
Okay, thank you.
Now, we have another witness who will be giving evidence in a moment, but in order to make the necessary arrangements, we'll have to have a short break. So we'll break now and resume as soon as we can. Welcome back, everyone. Our next witness is Mr. Adrian Pargeter, who has already given evidence to the inquiry, but whom we are recalling to deal with some additional questions. So my first step is to check that Mr. Pargeter can see me and hear me clearly. Mr. Pargeter, good morning. Can you hear me and see me?
Good morning. I can hear and see you, yes.
Thank you very much. Now, although you made the affirmation last time, I think we released you, so I think we better ask you to make it again. You should have the words of the affirmation on the screen in front of you. Do you have those?
I do.
Could I ask you, please, then to make the affirmation by reading them out?
I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Very good. Thank you very much. There are one or two housekeeping matters we have to deal with. Can I ask you to confirm that you're alone in the room from which you're giving evidence?
I am alone, yes.
Thank you. Can you confirm also that you have no documents or other materials with you?
I don't.
Right. And finally, can I ask you to confirm that your mobile phone is in another room and that you don't have any other electronic device with you which is capable of receiving messages?
I don't have any devices on me at all.
Right. Thank you very much. Now, you probably know this, but I just confirm that your legal representatives are with us in the virtual hearing room. They can, if they feel it necessary to do so, intervene in the proceedings, but they know and we know that there are other arrangements under which they can contact our counsel. So I'm going to ask them to keep their microphones and cameras switched off in the ordinary way. If we have a problem with sound or vision, we will take a short break while our technical support people sort it out. I think you'll probably still be giving evidence this afternoon. We'll have a break during the afternoon. We've already had one during the morning, so I think we probably won't go for another one during the morning. But if you feel that you need any additional breaks other than those already scheduled, just let me know and we'll do our best to accommodate you.
I will do.
Right. Is there anything you would like to ask me or raise before you start giving your evidence?
No, I'm fine, thank you.
Good, thank you very much. In that case, I'm going to invite Mr. Millett to put some questions to you. Yes.
Thank you very much, Mr. Chairman. Mr. Pargeter, first, can I ask you whether you can hear me and see me clearly?
I can hear you and see you, yes.
Thank you very much. I should begin by thanking you very much for returning to the inquiry to give further evidence. If you have any difficulty understanding any of the questions that I'm asking you, or you want me to put the question in a different way so you can understand it better, I'm very happy to do that. Could I also ask you please to keep your voice up so that the transcriber who is on this call can take down clearly what it is you're saying? Also, again, don't nod or shake your head. Please say yes or no, as the case may be. Mr. Chairman has already explained what we're going to be doing in relation to breaks today. And if we go into tomorrow, then there will be, I imagine, a scheduled break in the morning. Can you confirm that you gave evidence to this inquiry on the 7th, 8th, and the morning of the 9th of December 2020?
I can.
In addition to the 4 witness statements that you have given to the inquiry, which you confirmed in your evidence on the last occasion, you, I think, have now provided a further 5th witness statement to the inquiry, dated the 14th of January 2021. Is that correct?
That's correct.
And let's look at that then, please. It's at KIN 3024975. Can we please have that up? Is that the first page of your 5th statement?
It is.
Can you please go to page 7? You'll see a signature above your name and the date there. Is that your signature?
It is.
Have you read this 5th witness statement of yours recently?
I have.
Do you say that the contents of it are true?
I do.
Have you carried out any preparations in order to give evidence today?
In preparations, how do you mean?
Well, have you made any refreshment of your memory? Have you spoken to anybody? Have you looked at documents? Have you looked at previous statements in order to give evidence today?
Yes, I have. Around the fifth witness statement, yes, I have.
Around the fifth witness statement, what do you mean?
Around the subject that's contained within the fifth witness statement and the exhibits that I've attached to it.
Right. What preparations have you made around the fifth witness statement, as you put it?
Just looking at emails that were around at the time and checking back on the evidence that I gave on that last morning as well.
I see. Did anybody assist you with those preparations?
Just in providing documents.
Did anybody discuss the evidence that you're going to be giving today on those matters or any other matters with you before you came here today?
No.
Are you aware of 3 requests for further disclosure made by the inquiry of Kingspan?
I'm aware there's been more evidence requests, yes.
Are you aware of Kingspan's responses to those requests for disclosure?
No.
Do I take it from that you were not the ultimate decision maker at Kingspan in respect of Kingspan's responses to the inquiry's requests for further disclosure?
That's correct.
Right. On the last occasion that you gave evidence, the 9th of December 2020, you held the position at Kingspan of Director of Technical Marketing and Regulatory Affairs, Great Britain, didn't you?
I did.
Do you still hold that role?
I do.
Are you under any kind of internal investigation at Kingspan?
No.
Have you made or been subjected to any arrangements to leave Kingspan?
No.
And you're not under any kind of suspension?
No.
Now, I'd like to look back first, really by way of refreshment, if I may, to your previous evidence about the 2018 tests. And forgive me for going a little bit slowly with this, but let's take it in stages. You'll remember, I think, that on the 9th of December 2020, day 85 of this phase of the inquiry, you gave some evidence on the subject of Kingspan's testing of non-combustible insulation products in a BS 8414 test in the spring and summer of 2018, didn't you?
I did.
And am I right that that arose out of paragraph 12.3e of your second witness statement, which I'll show you? It's at KIN 3020824. KIN 3020824 at pages 113 and over to 114. There's your second witness statement on the screen. That's a bit slow coming up for you. There it is. That's the first page. And if we go to page 113, let's look together. Probably need 112 to show you where it starts, actually. Yes. This sits within a section, as you can see on the screen, headed 12, comments on issues 4 and 4A from the inquiry's list of issues last updated 25th September 2019. And then you say in paragraph 12.1, as well as being asked a number of questions by the inquiry, I have in mind the inquiry's list of issues last updated on 25th September 2019. I would like to add these comments to deal with issues 4 and 4A, and you describe them. I have previously contributed to submissions Kingspan made to the MHCLG on 14th of August 2018 in the consultation on banning the use of combustible materials in the external walls of high-rise residential buildings. The inquiry already has a copy of Kingspan's response to this consultation, but a further copy can be made available on request. And to an extent, these comments reflect those submissions. And then at 12.2, you say, experience and reflection has led us to the view that the most effective way of achieving the goal of improving the safety of building occupants in the event of a fire would be to ensure that all cladding systems are tested as complete systems in their intended configuration to BS 8414 standards so as to meet the requirements set out in BR 135. Experience suggests that this delivers better safety outcomes and in our view is best practice rather than simply banning of classes of certain materials. And then at 12.3, you say, you explain the rationale behind this view. And if we go over the page to E at the bottom of the page, page 113, we have the bottom of the page, you say it is not correct to assume that any combination of non-combustible systems are safe, irrespective of how they are assembled in a holistic system. Permitted product combinations can yield unsafe systems, systems comprising so-called non-combustible and limited combustibility insulation and or cladding systems have failed to meet BR135 criteria, such as, and then you set out 3 tests. Roman 1 failed test 1, and you identify that, 27th of October 2016. Then if we turn the page to page 114, you can see failed test 2, a test conducted in Australia in March 2018. And then test 3, failed test 3, you say, this test was commissioned by Kingspan and carried out at Exova in Dubai on 2nd of July 2018. The system comprised Rockwool Duoslab, which is rated A1, and Vitracor G2, which was understood at the time by Kingspan to be rated A2. The construction of the test rig was a replica of the Ministry of Housing, Communities and Local Government tests conducted immediately after the tragedy at Grenfell Tower. The test failed on the basis of thermocouple data, which is detailed in the enclosed BR135 classification report from Exova, which you exhibit. Now, I've read you that in full so that you can understand the questions that now, I think, flow from that. It's right, isn't it, that when you made that statement in October 2019, Kingspan hadn't searched for and given disclosure to the inquiry of all relevant documents relating to what I've just read to you from your second statement?
Kingspan hadn't, sorry, can you repeat the question?
Not searched for and given disclosure to the inquiry of all relevant documents relating to those comments that I've read to you.
I'm not sure.
Not sure. The reason I ask you that is because following further requests from the inquiry that I mentioned to you at the start of your evidence, Kingspan made further disclosures in January of this year, 2021, relating to the 2018 testing. You know that, don't you? Or do you not know that?
I wouldn't have known the specifics around that.
Right. Is it right that when you referred to documents here in your second statement dealing with these comments, that's part 12 of that statement, you were referring simply to those documents that you had selected or had been selected for you?
That I selected as part of what I was saying here.
But I'm right in thinking that you didn't commission or cause to be commissioned a full search of all documents relating to the testing in the summer of 2018?
No, I didn't.
Do you know why that was?
Why I didn't?
Yes, why you didn't.
No, I don't know.
Do you know why it was not done, regardless of whether it was you?
No, I don't.
Now, you can see from what I've shown you that you made no reference in this statement or made any disclosure of documents relating to a test conducted on the 22nd of May 2018 in Dubai, did you?
That's correct.
And you didn't do that until after your examination had completed in December 2020, had you?
That's correct.
Now, on the last occasion you gave evidence, 9th of December 2020, you gave evidence about a series of emails that were generated internally within Kingspan in March and April of 2018 about the testing done in that year. Do you remember that?
I do.
And I'll just put the email chains up in front of you, one by one, to refresh your memory of what you were examined about. The first of those is at KIN 404637.
Mr. Millett, before you go on, can I just ask Mr. Pargeter, is there a light in the room in which you're sitting which has failed? Because at the moment we can only see half of your face, I regret to say.
Yes, but what's happened is the main room lighting, I think because there's not enough movement, has gone into dim mode. So I'll switch this light on now, which is provided.
See if that's any better.
I know how to do it. Did you switch this on? Cycle one.
That's definitely an improvement.
The main lighting's now come on now. I've moved around.
Well, if you start waving your arms around, we'll understand that you're just trying to switch the light on. All right. Well, thank you. That makes a lot of difference. Thank you very much.
Thank you. Mr. Pargeter, you were speaking to somebody just then. Who was that?
That was just somebody nipping in to say, try and get the lights to work. They've gone back out again now.
I see. And can you confirm that they've now left the room?
Yes, they left immediately.
Yes, in the room with you.
No, there's nobody in the room.
Right, thank you. Now, let's have the first of those email chains up, please. KIN 404637. This was the email chain from early March 2018, entitled Re-Ulster Tests MH CLG Select Committee Lobbying. And you'll remember, do you remember this email chain?
Yes, I do.
And I don't want to read it all to you again at this stage, but you remember that. And then the second chain we looked at was KIN 404658. If we can have that up, please. And you'll recall that this was the chain of emails in April 2018, also relating to the testing to come and entitled Linear Route Action Plan. You recall those, yes?
Yes, I do.
And do you recall giving evidence that the aim of those tests that was discussed in those emails was to obtain evidence to support the need for full-scale testing of all systems and demonstrate that materials that are, quote, deemed to satisfy the linear route, unquote, don't automatically or always meet the criteria under BR 135 when tested full-scale to BS 8414?
That's correct.
And do you recall also that you were asked and confirmed that the system, the proposed system to be tested, as discussed in these March and April 2018 emails, was the system that was tested by Kingspan in Dubai on the 2nd of July 2018?
Yes, that's correct.
And you confirmed that, yes?
We talked about two systems. We talked in that evidence. There was the A2 system, which was the earlier test, and then there was the G2 system, which is the later test. So in discussion, we actually discussed both.
Well, not to my knowledge, Mr. Pargeter. Let's show you the transcript because this is, I think, what you're here to correct.
Yes.
Let's go to day 85, page 77, line 12. And I'd like to pick it up at line 12, where I say, let's move on. And I'd shown you the March and April emails, nothing else. And say, I asked you at 13, the test went ahead, didn't it? And it failed. Answer, yes. Question, and I think it went ahead, in fact, in July 2018, 2nd July, didn't it? Answer, I believe so. Just to be clear, we've got the test or classification report at KIN 50480. Let's have a look at that, please. It's report SR 0894 Vitricor G2 composite panel with 180 millimeters Rockwool duo slab insulation. And if we look down to the next page, the page references given, we can see just working through it, and this is an X-over test, the test sample description with siderized cavity barriers there, and then over the page, the next page, the insulation, 180 millimeters of Rockwool railing and the cladding panel there, Vitricor G2, and more details on the right-hand side. If you go to the next page, reference, you can see the drawings, the build-up. Do you have any reason to think that what was tested as per this classification report was different from what was discussed in the April emails we've been looking at? Answer, no, not that I can think of. Now,
Now, Mr. Millett, I'm sorry that I'm going to interrupt you again at this point, and I hope that Mr. Pargeter can remember the passages you've just shown him. But the reason I'm interrupting you is because, as I think most of those watching us will know, a national 1 minute silence is being held at noon today in remembrance of those who have died from COVID and the many others whose lives have been badly affected by it during the past year. We will observe that 1 minute silence, and we'll observe it now. Thank you all very much. Well, I'm sorry to interrupt the train of your thought like that, Mr. Pargeter. I hope you can remember the passages that Mr. Millett was trying to remind you of. Mr. Millett, would you like now to put your question?
Yes, Mr. Chairman, thank you. I've shown you the passage which was your evidence last time. Can we now look at your fifth witness statement, please, which we looked at before and to which you swore this morning? And I'd like to go to page 1, paragraph 1.1, please. Your fifth statement, KIN 3024975. KIN 3024975. Can we look down at paragraph 1.1? You say this witness statement is provided in addition to the 4 earlier statements which I've provided to the inquiry and relates to the 2 fire system tests carried out in accordance with BS 8414 Part 2, which Kingspan Insulation Limited, Kingspan, commissioned in 2018. This issue was addressed on 9th December 2020, my final day of evidence, and I wish to deal with an error that has been made in the evidence heard by the inquiry in relation to these tests. Then you go on to say, paragraph 3.1, if you can just turn to that, please. You can go to 3.1, which you'll find on page 4. Page 5, I'm sorry. 3.1, you say, I refer to the transcript of evidence that I gave to the inquiry on 9th December 2020, and in particular day 85 at pages 71 to 77, where when I was asked about some of the emails exhibited to this witness statement as AP5/1, I was then referred to the letter from Richard Burnley to Clive Betts, dated 6th July 2018, exhibited to this witness statement as AP5/3, and to the July test classification report. I was then asked, do you have any reason to think that what was tested as per this classification report was different from what was discussed in the April emails we have been looking at? Day 85, page 78, lines 7 to 10 of the transcript. I replied, no, I think. Although I've been asked by the inquiry to reply in writing via witness statements to several hundred questions, no questions had previously been raised specifically about the April 2018 emails, and so I had not reviewed them in detail previously. And under oral questioning, I could not recall that there had been 2 separate tests carried out in May and July 2018. I have now had an opportunity to review the emails attached to this witness statement, and I would like to correct my evidence. The emails exhibited to this witness statement as AP5/1 and AP5/2 are about the May test. The information sent to Clive Betts in the letter dated 6th July 2018 is about the July test. The answer I gave while giving oral evidence in relation to the question set out in paragraph 3.1 of this witness statement is therefore incorrect. Now, to be clear, when you say here at paragraph 3.2, the emails exhibited to this witness statement as AP5/1 and AP5/2 are about the May test, are you saying that they are only about the May test and have nothing whatever to do with the July test?
I think the main thrust of those emails and discussions was about the May test, the A2 test, rather than the G2 test.
Well, we'll come to look at those emails again shortly. Can you confirm anyway, for the purposes of clarity, that the 2 BS 8414 tests that we now know about, May and July 2018, were the only tests that Kingspan had undertaken using A1 and A2 cladding panels as part of its testing of the linear route to compliance?
With a non-combustible insulation, yes.
Yes. And you say that the May 2018 used Alucobond A2 panels as the cladding, and the July 2018 test used Vitricor G2 panels, yes?
That's correct, yes.
Do you say that not once during detailed examination of the topic when you gave evidence in December that you didn't at all recall that the May 2018 test took place?
No, it just didn't come to me, unfortunately.
Right. When did you first recall that the May test had been carried out?
I think probably when I got away from evidence and back at work, and I was told then that I'd missed the May test, and so then I started to look back at it, and we decided we needed to do another witness statement to correct that.
Who told you that?
Colleagues or the team that we're working with.
Colleagues or the team that you were working with. Can you tell me who reminded you of the May test when you got back to your...
It may have been our legal team, and said we need to correct this. We need to correct this evidence.
So it may have been your legal team.
Yeah, I think it was.
You think it was your legal team, right? And when you say your legal team, do you mean your independent solicitors, or do you mean a lawyer in-house at Kingspan?
I think it was our independent legal team.
Right. And when did this discussion take place? Can you recall?
Might have been a week or so after giving evidence. I had a few days off, and then I think it might have been discussed then. We needed to start to look into it, and that's when we prepared the 5th witness statement for January.
Right. Did they show you any documents as part of the refreshment by them of your recollection at that time?
There were some documents already. That one document with the red email chain on was one I'd already submitted, and it was looking back at that where I could see there that it does clearly state it was the A2 one, but on the day I just couldn't recall it as being a separate test.
When you were reminded of the May test by your legal team, did they show you any documents?
Just the ones that are attached to my witness statement.
Those documents were documents that had not previously been disclosed to the inquiry, weren't they?
Oh, I wasn't aware of that. I thought certainly the one with the red email writing on was one that had been previously submitted.
Did they show you any documents which had not, to that point, been disclosed to the inquiry?
I don't know whether they were disclosed or not, or what their status were at that time.
So can we take it that although you had forgotten, you say, the fact that the May test had taken place, your legal team were aware of it?
Yes, they would have been aware of it.
Right. Now, I don't want to ask you about communications between you and your legal team, but can you explain to us, to the best of your knowledge, why it was that Kingspan had not disclosed the documents about the May test, or which indicated in any way that a test in May had gone ahead?
Well, they had, because the documents you showed me on that day actually were about that May test. So certainly the one with the red email was nearly all about the May test and not about the second test in June. So that had already been submitted, and it was my failure to connect that at the time rather than the lack of evidence.
Do you say that the March and April emails relate to the test done only in May 2018 and not at all to the July test?
I can't quite remember the end of them, but certainly at the beginning of them, the early stages, certainly the big chunk in red, that was all about the A2 test and the discussions with Nick Jenkins, I remember being brought to, and the design of that test, all of that discussion was around the A2 test. We didn't actually discuss at all anything around design and installation processes of the G2 test, the second test in June.
You confirmed in your evidence last time that the April emails, the March and April emails we looked at with, including the red writing, related to the July test. Are you now saying that they related solely to the May test,
Yes.
or that they related to, you are saying that?
Yes, they related to the May test.
I see. When you were reminded, when you got back to the office after giving evidence and spoke to your legal team, of the fact that the May test had gone ahead, did you want to see any further documents about the May test which showed when it had gone ahead and with what rig it had gone ahead and what the results were?
Well, when I was reminded, when I got back, obviously I started to recall exactly what happened, and in those emails you can see the detail in that anyway. So that's the evidence that we've got. Right.
But that's not quite an answer to my question. My question was, did you want to see any further emails that related to the May testing in the respects I've identified?
I don't think I requested anything extra.
Right. Now, can we go to the April emails, KIN 404658. Just to have them on the screen. Do you recall that the linear route test was originally planned for the 10th of May 2018?
I don't specifically recall that.
Well, let's go to page 3 within this email run, just to refresh your recollection once again. This is part of the way through Nick Jenkins's 10th of April email, which starts on page 2. Sorry, starts on page 3 halfway down and then goes over the page. But it's towards the foot of page 3. Do you see there's a heading, BS8414 test proposal Dubai, to utilize the test slot booked by KIL on 10th May available for a test on the system comprised of materials deemed to satisfy BR135. So can you confirm that it's right that in fact the linear route test was originally planned for the 10th of May 2018?
Yes, that looks correct.
Yes. And it's right, isn't it, that in fact Kingspan tested a system containing K15 as the insulation product on the 10th of May 2018 at Exova Dubai, which was not a linear route system?
Ooh, I don't recall what we tested as K15 at the time.
Right, let me help you. Can we go to KIN 30020869, page 7. Now, this is page 7 of Appendix A to your second witness statement, which we've looked at. And I'd like just to show you box 15 at the very bottom of the screen you have in front of you. And it says there, 10th May 2018, Exova, Kingspan Insulation, Alpolic A2 ACM BML 400, K15, and then there's the BS 8414 report number and date, and the classification report. Now, that is not, is it, the test, the linear route test, the subject of the March and April emails, is it?
I don't think so. To be certain, I'd need to look at that DLR 1558, but I don't think so.
Well, have you been able to locate, or have you seen any documents or correspondence that shows that the test planned for the 10th of May on the system, the subject of the March and April emails, was then moved to the 22nd of May?
No, I don't think so.
Now, we've seen no records at all in Kingspan's disclosure showing how the May test was booked or paid for, or who the attendees were to be, or how the materials were shipped, or any drawings of the test. Are you able to explain why we haven't seen any of such documents?
No, I'm not.
Have you seen any such documents?
Into that detail about that, I don't think I have, no.
Have you asked to see any such documents?
No.
Why is that?
I didn't think I needed to.
Right. Surely in correcting the evidence you gave last time, so as to correct the record and ensure that the inquiry knows about the May test as opposed to the July test, did it not occur to you that the inquiry might like to see all the documents showing how the test was paid for, booked, who attended it, and what the results were?
I think provided everything that we've got, which would come under the search term. So I don't know what else there is to show.
Right. I see. Would Kingspan normally arrange a test, pay for a test, and organize people to attend it without any documents at all showing those matters?
No, I'm sure there will be documentation for those tests.
Yes. Now, you can see, as I've shown you from the schedule to your second witness statement, box 15 on page 7, that the test that went ahead on the 10th of May in Dubai was for K15 and Alpolic A2. Can we go to KIN 404658, page 1? This is the April email string we looked at a moment ago. And if we go to page 1 of that, you can see that there's some discussion about an Alpolic test. That's not the document I was after. I asked for KIN 404658, please. Yes. And if you go down, please, to halfway down page 1 there, you can see that Nick Jenkins writes on the 13th of April, a test slot for a part 1 test wall rig 2 at BRE Watford has become available for our use commencing 23rd of April. This was reserved for Tower 8 who I have been dealing with in connection with reclad solutions for a number of their clients' properties. This was offered to us on the back of a meeting with them in London yesterday. Any objections to taking advantage of this serendipitous opportunity? Question mark. It would save a small fortune in air freight and airfares. Then if you go up to the next email back, there's another email from Nick Jenkins, this time to John Garbett and to you, dated the 13th of April. And he says, and this is also subject relinear route action plan, copied to Jean Murter and Gilbert McCarthy. Tower 8, on behalf of Whitbread, have now decided that they will be utilising their test slot after all. So we remain focused on Plan A. As a result of my presentation yesterday, the test that they will carry out using their pre-booked slot will now be an assembly combining K15 and Alpolic A2. This will be to justify the retention of K15 as part of the reclad of multiple Premier Inns, changing the existing PE panels to Alpolic A2. And then at the very top of the email string, you can see that you respond or perhaps reflect internally. I think it's copied on actually to Adrian Pargeter and Adam Heath within Kingspan. Subject forward, linear route action plan, back to plan A, double exclamation mark. Now, I show you that to prompt your recollection. Is it right that you were at one stage going to use Tower 8's slot to do a linear route test, but then they took up their slot, hence back to plan A in Dubai?
That looks like what the proposal from Nick Jenkins was. Obviously, he was in discussions with Tower 8, right, and he thought it would be an opportunity to save doing it in Dubai.
I see. Do you know why you proceeded yourselves then to do a K15 and Alpolic A2 test in the 10th of May slot instead of the linear test that you had planned as Plan A?
No, I think that was already on the programme to be done with the Alpolic systems. So I think we'd already committed to that.
I see. If that is so, can you explain, going back to page 3, at the bottom of page 3, what then happened when you see it says at the bottom of page 3 to utilise the test slot booked by KL on 10th of May? Was there a decision to keep the Alpolic and K15 test as per the original schedule for the 10th of May, and then find another test slot for the linear route action plan test?
Which was in April, I think.
No, which was on the 22nd of May, as you told us.
There was a test in April, I think, wasn't it? It was the 8.2 test was April.
No.
Was it May?
Yeah. Well, your evidence, which you swore to this morning in your 5th witness statement, says there were 2 linear route tests, one in May and one in July.
Yes, okay. Yes.
What I'm seeking to get to the bottom of is how the date for the 22nd of May test came about. I've shown you the emails that show you that the 10th of May was in fact used for a K15 and Alpolic A2 test, which was not the linear route test. Here we see the proposal to use that slot for the linear route test. And in the end, the linear route test took place on the 22nd of May. My question is, what arrangements were made to fix that test or get the slot for the 22nd of May?
Oh, it would have been just with discussions with Effectis and see what slots they'd got available.
Were you involved in those discussions?
I think our guy who was in Dubai at the time, Adrian Pargeter, would have been liaising with Nick Jenkins and with Effectis to see what slots they got. I think that's how that came about.
Did those arrangements or communications happen in writing?
There would have been emails about that, I think, but I can't quite recall right now. But I think there would have been some discussion with Adrian Pargeter about it.
Right. Were you copied in on those emails or otherwise party to them?
I've certainly copied in on some of the correspondence between Nick Jenkins and Ad Pargeter out there doing the sort of final setting up, making sure the materials had arrived there and drawings were ready. I remember discussions of that being on email. Right.
Have you or did you review those emails when preparing to give your 5th witness statement?
Yes, I think I saw some on that, yes.
You didn't exhibit any, did you?
No.
Why is that?
I would assume they would have been captured in the evidence.
Now, I will check this, but as I stand here, I'm told that Kingspan have not produced those emails. Are you able to explain why that is?
No, I can't.
Was Nick Jenkins already in Dubai on the 10th of May? Do you know?
No, I don't know. I don't think he was, but I don't know.
Was he involved in the K15 testing that you undertook on the 10th of May using the Alpolic A2 panel?
I can't recall if Nick was there for that test or not.
Right. He was involved, I think, you just told us, but do confirm that in the testing that took place on the 22nd of May, which was the linear route test.
That's
yes?
correct. Yes.
Now, to be clear, at no time during your evidence on the 7th, 8th or 9th of December 2020, or in any of your 4 previous witness statements to the inquiry, did you mention a linear route test being undertaken by Kingspan in May 2018? Do you agree?
That's correct.
Why is that?
Because it was the G2 test, which proved the point that we were trying to make about the relying on small-scale testing. And it was that test that we then had a full report for and then used as evidence to the select committee and other consultations, not the A2 test.
Yes. Did you choose not to refer to the May test?
I don't recall it being a conscious decision to choose not to.
Well, in answer to my question why you didn't refer to it in your previous 4 witness statements or in any of your evidence before, you said, in answer to the question why, it was because it was the G2 test which proved the point you were trying to make. My question, I'll put it again, is, does that tell us that Kingspan had made a conscious decision not to refer to or reveal the existence of the May test?
I don't recall being conscious or not, but we wasn't referred to.
Now, as I've shown you, you do mention the July 2018 test, or what you call the G2 test, in your second witness statement to the inquiry at paragraph 12.3c in October 2019. When you were preparing that statement, casting your mind back, had you not recalled that there was also an earlier test in Dubai on the 22nd of May 2018?
I think probably then I would have understood that and recalled it, yes.
Yes, and so therefore did you choose when signing that second statement to make no reference to the May test, but only to refer to the July test?
Yes, I think we probably did. Yes, I think I probably did, because the G2 test is what we got the report on and the evidence on to submit.
Right. So do I take it from that you chose to refer to the July test because it proved your point, but chose not to refer to the May test?
Yes, I think that's correct.
And you chose not to refer to the May test because it didn't prove your point. Would that be fair?
That's correct.
Yeah. Now, in light of your new witness statement, we need to look again, I think, at certain aspects of the March and April emails and your evidence about it, which you gave on the 9th of December. And I'm sorry for going back over old ground, Mr. Pargeter, but I think it's probably necessary. Can we start, please, by looking at your 5th witness statement at paragraph 1.2, page 1. You say in paragraph 1. I want your 5th witness statement. I think we've got your 4th witness statement. Your 5th witness statement. I'll give the reference again. That's it. 1.2, please. You say both tests were carried out by Exova at their test facility at Al Futtaim in Dubai. The first test took place on 22nd of May 2018, the May test. The second took place on 2nd of July 2018, the July test. Both tests were carried out with cladding systems, including cladding panels and insulation products, rated either as limited combustibility, A2, or non-combustible, A1, and therefore deemed to be compliant with approved document B of the building regulations for use over 18 meters under the linear route. For the avoidance of doubt, neither of the systems tested in either the May test or the July test incorporated Kingspan K15 or any of the cladding or insulation materials used during the Grenfell Tower refurbishment project. Now that's what you say. Let's look at the March emails first. We saw them before. They are at KIN 404637, please. 4637. And can we go, one can do it on this actually. You can see that the title is Ulster Tests MHCLG Select Committee Lobbying. Can we go to page 3 and look in the middle of page 3, and you'll see there an email of the 2nd of March 2018 from Mark Harris to you, as well as others, including Gilbert McCarthy as a copy party. And it starts, "Hi Adrian, John et al. It's clear that Kevin Hollinrake is still pretty lukewarm about our draft letter stroke arguments to address MHCLG Select Committee and MP concerns." Now, just pausing there, do you agree that this email chain, starting with this email from Mark Harris about Kevin Hollinrake MP's concerns, is where the testing of a linear route system is discussed?
It is discussed in this email, yes.
Yes. And the reference in the first line there to a draft letter or arguments to be put to the select committee, what was that draft letter?
I think there was something that was being considered to submit to the select committee, and Mark had discussions with Kevin Hollinrake around this.
Right. Do you know whether that draft letter has been produced to the inquiry?
I don't.
You don't. Did the draft letter go to Kevin Hollinrake as a draft for his comments?
I don't know.
Was the draft letter an early draft or even an advanced draft of the letter that ended up being sent to the select committee on the 6th of July, 2018?
I couldn't confirm that. I would make that assumption, but I couldn't confirm that.
Now, do you remember whether or not this was the first time that the linear route system testing was discussed within Kingspan?
I wouldn't have thought it was the first time, because I'm being brought in here to, I think, to sort of try and make it happen. So I would assume that's been talked about earlier.
And we'll come and look at some documents about that perhaps shortly. Can we then go back to the April emails, which we saw earlier, KIN 404658. And these are all entitled Linear Route Action Plan, as we've seen. The first email in this chain starts on page 4, and it's the one with the red text. Can we go to that, please? It starts at the bottom of that page, as you can see, and it's from Mark Harris, dated the 9th of April 2018, to John Garbett, you, and a group of others, including Nick Jenkins, copied to Jean Murta and Gilbert McCarthy. The first paragraph in this email refers to a meeting in red letters that's taken place, and it says, "Hi all, the objective of the discussion was to look closely at potential issues related to the use of the linear route to compliance. In other words, provide evidence to demonstrate that the linear route approach has weaknesses and full-scale testing is essential for all systems. We reviewed evidence currently available and discussed how we can generate evidence for use in both the political arena and with the Hackett review team." Now, just pausing there, do you remember that on the 9th of December 2020, I asked you what discussion was being referred to, and you answered that you couldn't recall that discussion? Do you remember that?
Yes, I do.
Yes, and just for our references, that's at day 85, page 51, line 22. Now, on the 10th of March this year, so within this month, the inquiry received some 530 odd documents from Kingspan following the inquiry's request for disclosure. And included in that disclosure was your diary entry for the 9th of April 2018. Can we look at that? That's KIN 30254228. Can you confirm that this is your diary entry relating to the 9th of April 2018?
Yes, that looks like a diary entry, yes.
And if you look towards the bottom of the screen, you can see required attendees: John Garbett, Cook, Phil, it's Phil Cook, Adrian Pargeter, Roy Weghorst, Tony Ryan. Does that tell us that there was a meeting on that date?
Yes, I think there would have been a meeting on that date, yes.
And you can see towards the top of the page, or at the top of the page, subject, conf call, linear route compliance, discussion, stroke testing program, location, KIP, RMEC, boardroom, Holywell. Is KIP Kingspan Pembridge?
No, it would be Kingspan panels.
Right, Kingspan panels. And then RM, is that room?
I would assume so. It's their room location sequence in Holywell.
I see. I see. Now let's go back to Mark Harris's email of the 9th of April. at KIN 404658. And at the very, very bottom of the screen, bottom of the page, he says notes and actions as follows. And then if we turn to page 5, 1, data from failed BS8414 tests. We are aware of at least 2 BS8414 tests comprising only non-limited combustible materials that have failed to meet BR135 criteria. Key reasons for the failures are believed to be associated with the A2 cassette type, stroke robustness, stroke geometry, and stroke or the combustibility of the mineral fiber insulation system, binder content, stroke presence of polyethylene adhered aluminium foil. However, we do not have access to the reports or any rights to make this information public. Actions: test a Leukopanel A2 material in bomb calorimeter to determine heat release. NJ has sample. Also test Vitricore A2 honeycomb in bomb calorimeter. This testing is for information only at this stage. And then under item 2, which is particularly important, we looked at this last time in detail, Mr. Pargeter. We'll look at it again. KIL has 3 upcoming slots at Exover in Dubai and has agreed to make a slot on the 10th of May available for a test on a system comprised of materials, quotes, deemed to satisfy, unquote, BR135. Discussion during the meeting identified the following test proposal for a configuration that has the potential to fail BR135 criteria. Note the words potential to fail. A, BS8414 part 2, B, MMMF duo slab insulation. Just pausing there, the MMMF is man-made mineral fiber, isn't it?
Correct.
C, 38mm ventilated cavity. D, a Leucobond A2 ACM cassettes with, quotes, weak, quotes, structural specification. E, cavity barriers included. Actions, NJ to create drawing of A2 cassette assembly that could perform poorly. Note, that could perform poorly. Also, arrange fabrication, detailed test specification to be developed and agreed by all. AP, is that Adrian Pargeter?
Yes.
NJ, Nick Jenkins, yes? Yes. To arrange materials for test on 10th May in Dubai. KIP, stroke KIL, to share costs. Is that Kingspan Panels, stroke Kingspan Limited? Kingspan Insulation.
Yes.
I see. MH stroke AP, and MH is Mark Harris and AP is you, yes?
Yes.
Yes. Now, I've shown you that. We'll come back to it. I then read you the last paragraph of this email on page 6. If we can go to that, I'll read it to you again. Page 6. At the top of the screen, it says, I thought we had an extremely useful session this morning with actions that could deliver some very valuable evidence to support the need for full-scale testing of all systems and demonstrate that materials that are, quotes, deemed to satisfy, unquotes, the linear route do not automatically meet BR135 criteria when tested full-scale to BS8414. And you agreed in your evidence last time that this was indeed the purpose of the testing. Do you recall that?
That's correct.
Yes, and that's day 85, page 58, lines 2 to 4. And we then went back to the middle of page 5, and I'm reminding you of what happened last time in your evidence. If we go back to the middle of page 5, we went through in detail the weaknesses and the poor assembly that was being proposed for that test. And you called that test, I'm summarizing your evidence, so forgive me, a worst case scenario. Do you remember that?
Yes, that's correct.
Yes. And you still maintain that it was a worst case scenario kind of test?
The A2 test, the May test, yes.
Yes. And we then looked up at Mark Harris's email on page 5 of the 10th of April, which one sees on page 3. We go from page 5 to page 3. I'm sorry to do this in this order, but this is how it went chronologically. And you can see that set out the test program under BS8414 test proposal Dubai. And that said, and I've shown you this a little bit earlier this morning, let's look at it again. To utilize the test slot booked by KIL on 10th May available for a test on a system comprised of materials deemed to satisfy BR135, AP has advised that we need to get the full set of panels and components to Pembridge to be packaged for air freight to Dubai by the end of the day on Friday, 13th of April this week. This represents a challenge, but it is not impossible. And then if we go over the page, you can see there are various different things to be done. And under item B, we have some Aluco Bond A2 in stock from which we could fabricate the panels. And then D, Siderise have recommended we use the EnviroGraph cavity barrier products. These meet regs requirements, but their performance is expected to be poor. We will not utilize panel inserts, but attempt to cut the cavity barriers to suit the geometry of the panels. This will further weaken their performance. E, the panel system as drawn is expected to perform badly in spite of being A2 as it relies on bonded stiffeners and extrusions for its structural stability. The panel is not fixed on its vertical edges, and the bonded connection are expected to deteriorate and fail quickly in the BS8414 test. The way the internal corner is detailed will allow flames to bypass the vertical cavity barriers and attack the cavity of the wing wall. F, the vertical joint is ventilated and the fire will enter the assembly through this baffled joint. G, the horizontal joint is ventilated and the fire will enter the assembly through this baffled joint. And as I said to you before, and you agreed, you confirmed that that was the proposed test, that was the one that had gone ahead on the 2nd of July. I showed you the passage. Now that
was incorrect.
And you say now that that was incorrect.
Yes,
that
went ahead in May.
Right. Now, can we please look at paragraph 2.7 of your fifth witness statement? I think expands on what you've just said to us just now. Page 4 of your statement, 2.3. Sorry, 2.7, that's correct. That the system was tested on 22nd of May 2018 in accordance with BS 8414 by Exova, and in fact it passed the criteria set out in BR 135. I refer to the email which I sent at 0607 on 22nd May 2018, which sets out the preliminary results of the test. Kingspan did not commission a test report. In this particular case, the limited design imperfections had not adversely affected the overall performance of the system enough to mean that the system failed the test. We decided to test a different system using the test slot booked on 2nd July 2018. Now, just to ask the question again, why did you fail when giving evidence last time to mention that in fact there had been 2 linear route systems tested, first in May and then in July?
Just simply because I just could not recollect it on the day. My my powers of recollection.
Right. And did you make that point?
Sorry?
I'm sorry, I interrupted you. I'm so sorry, Mr. Pargeter. You said my powers of recollection. Did you want to continue?
Just deserted me for that section of the evidence.
And you say it in your witness statement of paragraph 3.2 that you couldn't recall the May test. I have to ask you, is that really true?
Well, yes, it is absolutely true, because I mean, it was far more beneficial if I had remembered it, because we could have cleared up the later accusation around misleading the select committee. So
how much?
Just a genuine. I just couldn't recall it.
For recollection, how much had the May test cost in total, including freight, design, supply costs, and things of that nature?
I don't recall exactly.
Do you know which budget it came from?
I think it would have been a shared budget between ourselves and Mark Harris's budget.
Yes, we saw a bit of that in the email, didn't we?
Yes.
Yes. Who had authorised the spend on the May test? Was that a combination of you and Mark Harris?
Yes, that's correct.
And do you know who had arranged the test to be moved from its 10th of May slot to the 22nd of May slot?
No, I don't recall why that moved from the 10th. It may be because we were struggling to get the materials there on time, and we moved it to the 22nd to make it more feasible. I don't recall the detail.
Was there not a degree of surprise or perhaps disappointment within Kingspan that after spending so much time and money on this test, it in fact passed?
I think there was a little bit of surprise, yes, and a bit of disappointment. I'd agree, yes, because we from what we'd seen from other evidence of other tests, that was quite likely to really struggle in the test, but it passed. So,
yes, was it not also very inconvenient that your attempt at poor performance, as is said in the April emails, had failed, so that as we'll see, you had to try again? Was that not very inconvenient?
Yes, it was. We'd have to try another route, but we'd identified as a potential.
And would I be right in thinking that the unexpectedly successful result of the May test that dealt something of a blow to your case, that 8414 system testing was the only reliable way to ensure fire safety rather than relying on the use of non-combustible products?
So what was the question?
Well, the fact that the May tests passed must have dealt a blow to your case. The 8414 system testing was the only reliable way of ensuring fire safety.
Well, it meant we didn't have any empirical evidence we could use. We knew of anecdotal evidence which we couldn't use. But obviously we wanted to generate and have empirical evidence to prove the anecdotal, and it didn't do that, so we didn't use it.
Yeah, and I'm suggesting that was a bit of a blow because you didn't have empirical evidence to back up your argument.
It was, yes, it was a disappointment, yeah.
Yes, disappointment. And does it remain your evidence that despite your involvement in setting up the test, the money spent on it, in which you were involved, the surprise and inconvenience of the test passing, and the blow that it dealt to your case message, you never recalled the successful May test when you were giving evidence on the 9th of December? No,
I didn't recall it.
I have to suggest to you that that's not really credible, is it?
Well, what other reason would I have for withholding that? It doesn't make sense. I genuinely didn't recall it. It would have been far better if I had have recalled it at the time.
You asked a rhetorical. Sorry, you started speaking again as I was about to ask my next question. Do you want to?
I was going to say there's no advantage to us, no purpose for us, for me forgetting about that at all.
If you ask a rhetorical question, what other reason would I have for withholding it? One reason might be that you'd never hitherto, to that point, mentioned even the existence of the May test and the blow that it dealt to your case, let alone disclosed any documents about it. That would be a good reason for not mentioning it when you were giving evidence, wouldn't it?
No, I wouldn't have thought that, no.
What was your reaction when the May test passed, Mr. Pargeter?
I think it was we'd got a plan B, which was the G2 test. So it was on to plan B.
Yes, and we'll see an email shortly where that expression plan B is used. Can you remember what the reaction of your team was?
They just phoned me. I think Adrian Pargeter phoned me and said, or may have sent me an email, I can't quite recall, but just said, we've looking at the early results on this, because we can tell before we get the official details whether it's passed or not. Looking at the early results, this looks like it passed, and so it passed.
I see. He told you that he had early results, did he?
Well, he was at the test, so he could tell if it had failed or if it passed. And his indication, his thoughts were it would have passed because it didn't. It wasn't terminated early or anything like that.
Right. Did you have a meeting after the news was received of the test pass?
I can't specifically recall a meeting, but we certainly exchanged emails.
Exchanged emails? Yes, you're nodding. I think you have to say yes.
Oh, sorry, yes, exchanged emails.
Yes. Do you remember whether you discussed the result of this May test with Jean Murter?
I didn't personally.
You didn't personally. Do you know whether anybody else involved in the test did?
I couldn't confirm.
Did you discuss the result with Gilbert McCarthy?
I didn't, no.
Again, do you remember whether anybody else in your team did?
No, I don't.
Did you discuss the result of this successful test with Richard Burnley?
Yes, I think I would have discussed that with Richard Burnley, yes.
I see. Did you discuss it with him by telephone or in writing?
Oh, I can't recall. Certainly it would have been via a conversation on the phone, possibly by email, but certainly would have been on the phone.
Right. And what about John Garbett? Did you discuss it with him?
Yes, John Garbett would have been aware of it as well.
What, telephone or email? Can you tell us what the medium of
Not
communication?
specifically, but again, I mean, I think John would have been copied in on an email. I think there might have been an email from me to say, going out to that team, that it's John Garbett and maybe Mark Harris, to say that the test has passed. We're going to move on to
Yes.
Plan B.
We'll come to that in just a moment. There isn't. You're right. There is an email to that effect, and it's exhibited to your fifth statement. Do you remember discussing the failed fail, as it were, the success with Nick Jenkins?
Not specifically.
Did Nick Jenkins not share his thoughts with you on why he thought the test had passed, given the number of weaknesses that he'd introduced?
No, not that I can recall that he gave any detail on that now.
Did you not want to know?
Not really, because we were aware of the design, and it had passed. I think there was nothing more to know, really.
Right. Were you not curious to know why it was that, given the number of weaknesses that you'd introduced into the system, so as to enhance its risk of failing, or poor performance, to use your words, or the words at the time, in fact, the test had passed?
No, it just did pass. I think it'd be hard to analyse exactly why it did pass. It's difficult to analyse why something might pass. Maybe a bit easy to analyse why something might fail, but because it passed, it passed.
I see. Now, we know there was no test report commissioned for the May test. Was that a result of a decision not to seek one?
Yes, I think so. We didn't need it. It was not of any value to us, so we didn't commission a test report.
Do you know who made the decision not to commission such a report?
No. I think because it was a BML system, a Booth-Moory cladding system. We thought that maybe Booth-Moory might have some value in the test. So, and a test report being a pass might have had some value to them, but I don't think they needed it. So we just decided not to pursue it.
I see. When you say a Booth-Moory cladding system, do you mean one designed by Nick Jenkins?
Yes.
Yes, I see. Is the reason why you commissioned no test report for the successful May test that you were only interested in having a record of failure for this test, not a record of success?
Well, we were only interested in a report of failure because that's what we needed to provide the empirical evidence, and so we didn't need a pass report.
I understand that. And is the not needing a pass report for that reason the reason why you didn't commission one?
Yes, there was no need for one.
And is it right that a record of success would damage your argument that even systems containing non-combustible products could fail ABS 8414 test?
I don't think it would damage it, because there are probably other systems out there that have been tested and have been fine. So I don't think it would have damaged it necessarily.
Mr. Chairman, I'm 4 minutes away from 1 o'clock and I'm going to change topic. It's unlikely that I'm going to get through the topic before a convenient.
Well, it might be more sensible just to stop now than mightn't it?
I think it would. I hesitate to finish a little or stop a little early.
I know you don't like doing that, I know that, but I think it can sometimes be the better course. And I don't suppose Mr. Pargeter is going to complain about having an extra 3 minutes for lunch. Mr. Pargeter, we're going to stop there now, so we can all get some lunch. We'll resume, please, at 2 o'clock. And I'm sure you remember this, but I'm going to say it to you again. Please don't talk to anyone about your evidence or anything relating to it over the break. All right?
Of course, yes.
Thank you very much. We'll see you at 2 o'clock.
Thank you.
Thank you.